Welcome to IP Concerns Deep Dive, the podcast version of our IP Concerns blog from Cascade Law Group. Here, we unpack intellectual property-related, real business and brand protection topics in a way that actually makes sense, no legal experience required.
Imagine waking up tomorrow morning, pouring your coffee, checking your emails, and just suddenly discovering that someone else legally owns your brand name.
It is the ultimate nightmare scenario for a business.
Absolutely. And I am not talking about a parody account on social media or some cheap knockoff logo that vaguely resembles yours. I mean, your actual exact brand name.
Right.
But they own it in another country. Today, we are taking a deep dive into an article titled "The Global Threat of Trademark Hijacking." And our mission here is to give you a shortcut to being well-informed about a corporate espionage tactic that, frankly, operates right out in the open.
It really does. It sounds like something from a spy movie, but it's happening every day.
We are going to explore the mechanics of how this works, how a massive, globally recognized brand recently fell victim to it, and crucially, why you, the everyday consumer, to be paying very close attention to this threat.
Because the mechanics of it, they reveal a really significant vulnerability in international commerce. Your disbelief is totally warranted because the scenario sounds completely implausible at first glance.
It really does. I mean, how could someone just take your name?
Exactly. However, this is an increasingly common problem. It is being driven largely by the friction between how quickly digital business can scale globally and how incredibly slowly international legal frameworks adapt to that speed.
Yeah, the law is always 10 steps behind technology.
Always. As the world gets smaller for businesses leveraging digital infrastructure to reach new markets, the procedural loopholes for bad actors are actually widening.
Okay, let's unpack this, because when most people hear the phrase trademark hijacking, I think the immediate mental image is someone copying a logo and just slapping it on a t-shirt in a basement somewhere.
Right, the classic bootleg operation.
Yeah, exactly. But according to our source material, that is not an accurate picture at all. This is far more sophisticated. It is actually a third party exploiting very specific procedural loopholes to take legal, documented control of a legitimate brand's trademark rights.
A paperwork heist is probably the most accurate way to frame it.
The paperwork heist, I like that.
Yeah, and the hijacker's playbook is surprisingly straightforward, which makes it particularly insidious. It generally unfolds in 3 distinct steps. Step 1, the hijacker forms a new company. But they deliberately give this corporate entity a name that closely resembles an already existing successful brand.
Okay, but how does simply incorporating a company under a similar name actually give them any leverage over international trademark rights? It just seems like there would be safeguards against something so basic.
You would think so. But that leads to step 2, where they exploit what are known as first-to-file jurisdictions. What's fascinating here is how these specific legal systems prioritize bureaucratic efficiency over historical use.
Meaning they just care about who gets the paperwork in first.
Precisely. In a first-to-file jurisdiction, trademark rights are awarded to whoever submits the paperwork first. It fundamentally does not matter who actually created the brand, who designed the logo, or who's been utilizing it in commerce for years. Speed is the only metric evaluated by the system.
Wow.
Whoever gets the application into the registry first secures the presumptive legal rights to the trademark in that territory.
Which completely bypasses the traditional concept of building brand equity. You could put years of effort into a brand, but if someone just beats you to the filing office in one of these jurisdictions, they gain the upper hand.
That's exactly how it works.
But even in a first-to-file system, don't trademark authorities require some proof of legitimacy? That brings us to step 3 of their playbook, which involves submitting false corporate records.
Yeah.
Our source material notes that these hijackers use misleading declarations to make their paperwork look completely routine.
Right.
I am just struggling to understand how major international bodies just accept fabricated documents without verifying them.
It really comes down to a glaring gap in international bureaucracy and database integration. The goal of the bad actor is just to blend into the sheer volume of global filings. Trademark offices worldwide are processing thousands of these applications daily.
Just a massive stack of paper every day.
Exactly. They operate on a mandate to process paperwork efficiently, not to act as international private investigators. If the forms look standard and the hijackers have submitted the required, albeit entirely falsified corporate records, the filings often slip right through the cracks.
Because nobody is checking the homework.
Right. There simply isn't a centralized global system cross-referencing local state registries to verify the authenticity of every applicant.
So if they pull this off and the paperwork is approved, the hijacker suddenly legally holds the trademark rights to a brand they didn't build. They didn't invent the product or invest a dime of capital into marketing.
Nothing.
Yet they possess the legal keys, forcing the original legitimate earner to fight a massive uphill battle just to reclaim their own intellectual property.
It forces the true owner into a highly disadvantageous defensive position.
Yeah.
In the eyes of that specific territory's legal system, they are no longer the undisputed owner.
Or the outsider.
They're reduced to the status of a challenger trying to overturn a legally registered trademark, which entirely shifts the burden of proof and the massive financial burden of litigation right onto the victim.
This brings us to the real-world case study detailed in our source material, and it involves a brand that many of you listening likely have in your closets right now, which is Alo Yoga. They are one of the most recognizable athleisure brands in the world.
Very recognizable. And their situation perfectly illustrates just how high the stakes can be and how these theoretical vulnerabilities are exploited in actual practice.
Here's where it gets really interesting, because the specifics of Alo Yoga's recent lawsuit outline a particularly aggressive strategy.
Very aggressive.
According to the complaint, a Colorado-based entity allegedly formed a company with a name that is nearly identical to Alo Yoga's established trademarks. But they didn't stop at just picking a similar name.
No, they took it much further.
The defendants are accused of submitting entirely false information to state authorities. On these official filings, one of the defendants reportedly identified themselves as Alo Yoga's chief executive officer.
Taking over a corporate identity on state documents is a massive escalation from simply filing a competing trademark in a foreign country. It represents a coordinated effort to actually hijack the operational identity of the business itself.
The source material has a great, very dry observation about this tactic, calling it an unexpected career move, to say the least.
That's a good way to put it.
But filing fraudulent papers in Colorado is one thing. The defendants allegedly used those fake documents to take the next step, filing trademark applications with international authorities.
The global authorities, yes.
Specifically, the source material notes they targeted China's National Intellectual Property Administration, and they also went through the World Intellectual Property Organization, or WIPO. Does that mean a localized fraud essentially becomes a master key for international filing?
That is a very accurate way to conceptualize it. The international systems, particularly frameworks facilitated by WIPO like the Madrid Protocol, they allow an applicant to use a basic home application, in this case, the one filed using the allegedly fake Colorado documents, as the foundation to seek trademark protection in over 100 other countries.
Over 100 countries from one fake document.
Yes. WIPO does not independently audit the Colorado Secretary of State's database to verify if the person signing the forms is the actual CEO. They just rely on the documentation provided.
So by targeting WIPO and China's NIPA, the hijackers were weaponizing the gap between localized corporate registries and international trademark treaties.
And they're also weaponizing the territorial nature of trademark rights. This is a crucial concept to grasp. We live in an era of borderless e-commerce, but legal protections are strictly bound by geography.
So a win at home doesn't mean a win everywhere.
Exactly. A trademark secured in the United States offers no automatic protection abroad. By filing in China and through WIPO, the bad actors were attempting to lock Alo Yoga out of the global market using the brand's own localized oversight against them.
If Alo Yoga had not caught this, or if those applications had gone completely unchallenged, what was the practical worst-case scenario for the company?
The worst-case scenario. Alo Yoga could have found itself entirely legally barred from using its own name in key global markets.
Completely shut out.
Entirely. If a brand wants to manufacture in a country where someone else holds their trademark or sell products to consumers there, they cannot legally do so. They become the infringer in that territory, subject to having their own goods seized at customs.
Like their own goods?
Yes. The legitimate brand is typically forced to abandon that market entirely, or, and this is often the primary financial motive of the hijacker, they are forced to pay a massive ransom to buy back the rights to their own intellectual property.
It operates essentially like a corporate ransom situation.
It is extortion, practically speaking.
But the source material makes it clear that Alo Yoga is pushing back aggressively. They are not taking this lying down. They are suing for trademark infringement, false designation of origin, unfair competition, and identity theft, given those wild allegations regarding the executive filings.
They threw the book at them.
They are seeking injunctive relief. the dissolution of this allegedly fraudulent entity, and damages tied to this attempted takeover.
If we connect this to the bigger picture, pursuing those specific legal remedies is absolutely critical. Injunctive relief is designed to legally force the bad actors to stop using the name immediately while the case proceeds.
To stop the bleeding.
Exactly. Seeking dissolution aims to erase the fraudulent corporate foundation they built in Colorado. However, untangling this web is far from an overnight process, and it really exposes the severe business disruptions that occur during these disputes.
Even if the initial filing was clearly fraudulent, I imagine the process of challenging it through the proper international legal channels must take an incredible amount of time.
Unwinding a hijacked trademark, especially once it has entered international registries, is notoriously slow, expensive, and shrouded in uncertainty. The legal challenges required to overturn a registered trademark across multiple international jurisdictions can take months, or very often years, to fully litigate and resolve.
And during that timeline, the brand is just operating under a cloud of uncertainty. They can't just pause their global business operations while waiting for various international tribunals to issue rulings.
They really can't.
Yeah.
While the legal battle drags on, the legitimate brand may face blocked trademark applications of their own in those regions. Their enforcement rights are severely weakened, meaning they lack the clear legal standing to stop other unauthorized sellers or copycats from entering the market.
It's an open season on their brand.
It is. Furthermore, their entire global expansion roadmap can be derailed. A company cannot launch a multi-million-dollar marketing campaign or sign lease agreements for retail spaces in a new country if they do not possess the clear legal rights to their own brand name in that territory.
The source material highlights a very specific vulnerability window that these bad actors look for. It seems they are highly calculated regarding when they choose to file these fraudulent applications.
The timing is rarely a coincidence. In the first-to-file jurisdictions we discussed, hijackers understand that legitimate companies often delay their international trademark filings until their expansion into that specific country is imminent.
Trying to save some money early on, I assume?
Mostly, yes. They do this primarily to defer the substantial costs associated with international registration. Bad actors monitor market trends, they observe a brand gaining traction in its home country, anticipate the impending global expansion, and intentionally strike during that exact window of opportunity. They file just before the legitimate brand is ready to make its move.
So what does this all mean? We've been discussing multinational brands, international filing jurisdictions, and complex corporate legal battles. But for the listener who doesn't own a global corporation, what does this actually mean for them? Why should you, the everyday consumer, care about these procedural disputes?
Because trademark hijacking has a direct and significant impact on the consumer market. It is not just an isolated corporate issue happening in boardrooms. When a brand's legal rights are hijacked and tied up in prolonged territorial disputes, the immediate consequence is often a flood of unauthorized or counterfeit products entering the supply chain.
Because the legitimate brand has temporarily lost its legal authority to have those fake products seized or removed from e-commerce platforms, they can't stop them.
Precisely. The market becomes saturated with products that might look entirely legitimate on the surface. They bear the familiar brand name, they have the recognizable logo, but they completely fail to meet the actual company's quality control or safety standards.
So a consumer could purchase a piece of athleisure wear, assuming they are supporting a trusted company and receiving the premium materials or manufacturing guarantees associated with that brand.
But they aren't.
Right. They are actually receiving a subpar product manufactured by the hijacker, perhaps using inferior stitching or unsafe textile dyes.
It systematically degrades consumer trust. And beyond the direct risk of purchasing a compromised product, there is a substantial economic ripple effect here. We discussed the massive legal fees and the years of litigation required to resolve these international disputes. Those costs do not simply vanish into thin air.
Those expenses have to be absorbed somewhere on the corporate balance sheet.
They're ultimately absorbed by the consumer.
Right.
When a company is forced to divert millions of dollars away from their standard operations to fund international intellectual property litigation, that capital is no longer available for research development or improving the customer experience.
It just becomes a sunk cost.
Yes, it results in hidden costs passed down. Fewer choices on the shelves, delayed product innovations because the expansion budget was entirely drained, and inevitably higher prices at the checkout counter. The consumer is indirectly funding the brand's legal defense against these bad actors.
We are all essentially paying a premium to cover the cost of a fragmented international legal system. Looking at the defense strategy, the source material outlines lessons that trademark owners can extract from the Alo Yoga case. Given that hijacking rarely announces itself politely, what does a proactive defense actually look like? If I'm a mid-sized brand just starting to gain traction online, how early do I actually need to be thinking about filing in Europe or Asia?
Waiting until the expansion is imminent is waiting too long. That is the vulnerability window. The primary takeaway is to register early and strategically. Trademark protection needs to be evaluated through a much wider operational lens.
How wide are we talking?
It must align with where the manufacturing actually takes place, the specific routes of the global supply chains, and the long-term future expansion plans, rather than solely focusing on the territories where the company is currently selling products today.
It requires planting flags across the entire anticipated footprint of the business before the business even actually arrives there.
Exactly.
But beyond just filing trademark applications early, how does a brand catch someone trying to pull the fake CEO maneuver we saw in the Alo Yoga case?
That requires continuous active monitoring. Brands must utilize comprehensive trademark watching services to monitor new applications globally. But crucially, they also need corporate record monitoring.
Keeping an eye on the state registries, too.
Yes, it is essential to monitor state and international registries to see if unauthorized entities are forming LLCs using the brand name or filing fraudulent executive declarations. Catching these suspicious filings in their infancy before they become legally entrenched in the international system makes unwinding them significantly more manageable.
And if a brand does uncover a suspicious filing, the response time seems critical. The source material emphasizes acting quickly and securing specialized help, noting that delays drastically limit available legal remedies. Is the international system really that unforgiving to a slow response?
Time is absolutely of the essence. Attempting to navigate international intellectual property law, dealing directly with organizations like WIPO, or fighting first-to-file claims in foreign jurisdictions requires a highly specialized skill set.
It's not a DIY project.
Not at all. The deadlines for opposing fraudulent applications are often strict and incredibly unforgiving. Handling it internally without expert counsel can often severely damage the brand's legal standing and permanently lock them out of a market.
The article actually points out that for professional guidance and support with protection and enforcement, readers should visit cascade-lg.com. It is clearly not a situation where a company can afford to learn through trial and error.
No. The complexity of the international treaties involved demands specialized representation to ensure the brand's rights are effectively protected and enforced across all these different borders.
As we wrap up this deep dive, there are several key takeaways to process. The most striking to me is the friction between our instantaneous global economy and the fragmented territorial nature of trademark rights.
It's a massive disconnect.
There's also the surprising audacity of the hijackers, stealing corporate identities and exploiting bureaucratic gaps in systems like WIPO to execute international paperwork heists. And finally, the realization that this corporate espionage has a tangible economic impact on the prices you and I pay, the pace of innovation, and the safety of the products we consume every day.
This raises an important question about the legal frameworks we currently rely upon. We are operating systems designed for a localized analog past and trying to apply them to the realities of hyperconnected digital global commerce.
Which leaves a fascinating thought to ponder. Since we live in an era of borderless e-commerce, where a brand can go viral worldwide literally overnight, yet we still rely on a fragmented, first-to-file legal system that essentially rewards speedy bad actors. Will the international community eventually be forced to create a single, unified global trademark system? Or are legitimate brands, and by extension all of us consumers, doomed to play a perpetual, highly expensive game of international legal whack-a-mole for